Let's get rolling.
See, it turned on the TV.
Oh, I see. Okay, great. Good morning and welcome to the Pinellas County Board of Adjustments and Appeals. We've received your cases in advance and have studied them, and in some cases visited the sites. Please understand that we don't bring these cases. We are citizens tasked with weighing the evidence submitted in order to make the most informed decision possible. We have no personal interest or stake in these cases except for the overall good of the community. The staff has recommended on each case, and that recommendation is input only and may not necessarily be the opinion of this board. If you're planning to speak against any application, you must be sworn in prior to testifying up front. If you have not been sworn in, please do so now with the clerk at the front of the table. And this is how we will proceed. When your case is called by staff, the applicant should come right to the podium and give your name and address. The applicant will then present their case, including comments from any supporters in attendance. Comments by supporters should be new information and not just expressing the expression of support. The applicant may display the volume of support by show of hands. Speakers will have 3 minutes. Opponents will then be given the opportunity to state their objection. If there are numerous opponents, it is preferable for them to select 1 or 2 speakers, and they will have 3 minutes as well. Subsequent objectors should add new information, not just rehash prior stated objections. Opponents may display the volume of objectors by a show of hands. This will be the only opportunity for opponents to state their side. The applicant will then return solely to rebuke comments of any opponents and may not bring any new information or testimony at that time. And finally, we will close the public hearing. The board will discuss the case, make a motion, and vote. Now our attorney will provide additional information on the procedures.
Thank you, Mr. Chair. The matters heard by the Board of Adjustment and Appeals are quasi-judicial in nature. Please note that only competent, substantial, fact-based testimony or evidence may be considered by the board in deciding the matters before it. Pure speculation or opinion, not based on competent facts, cannot be legally considered by the board. Lay testimony with fact-based support, including but not limited to meeting minutes, surveys, engineering reports, etc., may be considered competent and substantial evidence. Thank you.
You're welcome. And with that, staff, let's please call our first case.
Good morning. First case is VAR 23-27. This is a variance request to allow for the construction of a screen room with a composite roof having a 3-foot setback from the rear property line where 10 feet is required for the property located at 1963 Trailside Drive in Palm Harbor. Staff is recommending conditional approval. This property is part of a 25-unit, it's a townhome master plan development known as North Point in Palm Harbor. This townhome unit is positioned at the end of a cul-de-sac on the existing subdivision with no immediate neighbors to the west and south. So the applicant is proposing to construct a screen room with a composite roof over an existing patio closer to the southern property line than would normally allowed. This property, since it's on a cul-de-sac, there is significant curvature in the profile along the front of the lot, which is causing the building to be set back further than other buildings in the subdivision that are not on the cul-de-sac. So this proposed screen room is really the only logical location for this to be installed. Additionally, other units in that neighborhood have installed screen rooms. They've been able to meet the setbacks because the way the building sits on their lot, but with the curvature of this one, we see that that's the reason why. And also they have approval from their HOA as well. So.
All right, thank you. And is the applicant here? All right, come on up and give us your name and address, please.
Okay. Lucy Easley, 1963 Trailside Drive.
All right. Do we have any opponents in the audience? Anyone against? And do we have anyone online that's dialed in this morning for opposition or support?
Seeing no opponents, I'm going to move for staff recommendation of conditional approval in accordance with the findings of fact as outlined in the staff's recommendation.
Second.
All right, we have a motion and a second. All in favor?
Aye.
All opposed? All right.
That was easy,
Thank
huh?
you.
Congratulations.
We did away with the online stuff.
What's that?
We did away with the online.
Oh, we did? Okay, good. That's
Our
good.
next case is VAR 23-28. This is a variance to allow for the proposed on-site building to occupy 23.4% of the primary roadway frontage along US 19, where the Land Development Code District Design Criteria requires 40% in a CP zone for property at 35952 US Highway 19 North in Palm Harbor. Staff recommends conditional approval. So we have the district design criteria, which was put in place to allow more of the building frontage to occupy frontage versus the frontage of the property. This site is already developed with a car wash that occupies a majority of the southern portion of the property. We do have in the district design criteria that automobile-oriented uses are exempt from this roadway frontage requirement. So that car wash did not have to go through this process. This tenant would. It's a coffee shop that's mostly a drive-through, but does have walk-up customers, so does not qualify as an auto-oriented use. So they're looking to occupy approximately 109.4% of the roadway frontage. That's not associated with the existing car wash. So their building frontage percentage would end up being 23.4%, which is less than the 40% required. We find that this will allow for more safer vehicular circulation with the drive-through. If they had to go larger, it could pose a safety hazard with vehicular circulation on the property.
All right, thank you. Is the applicant here? Come on up. Name and address, please.
Good morning. Sean Cashin, 13825 ICOT Boulevard, Clearwater, Florida. I have nothing to add to Mr. Schotterbach's summary, and I agree with the recommendation for approval. So I'm here to answer any questions you may have.
All right, and is there anyone in the audience that's opposed?
Seeing no objections, I'm going to move for staff recommendation of conditional approval in accordance with the findings of fact as outlined in the staff's recommendation.
Second.
All right, we have a motion and a second. All in favor?
Aye.
Anyone opposed? All right.
Thank you.
Congratulations.
Appreciate it.
Yep.
Michael, we had a similar case to that with the Wawa in Lellman area, and it occurs to me that there should be a way to administratively address these cases.
And we did after we had the Wawa. I think there was also another Circle K. So we had a couple, and we made that change to the code to take out auto-oriented uses. Now, if this was just a drive-through only, they would have qualified as an auto-oriented use, but because they have people parking inside service, it doesn't. So,
Is the purpose of this ordinance to avoid having parking lots facing 19? Is that the reason?
no, you can have a parking lot. It's to have more building frontage, kind of bring the building forward, more easier pedestrian access for people riding transit or bicycles, and it's not just on US 19, so it's on any commercial properties.
All right, thanks.
All right. All right, let's,
So our next case, VAR 23-29. This is a variance to allow for the construction of a 1,628 square foot detached accessory dwelling unit, where 750 square feet is the maximum permitted, for the property located at 9225 95th Street North in unincorporated Seminole. Staff is recommending denial. We find there are no special conditions or unnecessary hardships, and the request is not the minimum variance necessary that warrants a proposed accessory dwelling unit to exceed the maximum square footage allowed. So the subject site is approximately 1.42 acres and is currently undeveloped. In 2022, the applicant submitted applications for site plan review and administrative waivers, so for a two-lot subdivision, detached single family, and waivers for sidewalks and roadway width. The site plan process stalled and the site plan eventually expired. So we recognize that accessory dwelling units are commonly used to mitigate the shortage of affordable housing by providing these small dwelling units that are ancillary to the principal residence. This proposed one-bedroom, 1,628 square foot accessory dwelling unit exceeds the maximum size normally allowed per code by 878 square feet. So again, staff finds there's no special conditions or circumstances that are peculiar to the land that would require a larger accessory dwelling unit. The applicant can split the lots as originally proposed and comply with all subdivision and plating-related requirements. And we find also that it's not, doesn't meet the minimum code deviation since it's 115% higher than allowed.
Okay, is the applicant here? Come on up, please. We need to get all names and addresses.
No, just-
My name is Ed Martinez, and this is my wife Carol, and my daughter Katrina, and our son-in-law Alex.
Kind
Would
of stand
li-
in the middle there, please.
Sure.
We'll hear you better. And
Okay,
the
sure.
address? Sure.
We live at 9044 Cypress Trail. We purchased this property, and we were hoping to have 2 homes on there so that we could help them with their grandchildren. And we are asking for the variance for various reasons. First of all, the property is very large and can accommodate 2 homes easily. To your point, it was very expensive and very timely to try to do a subdivision because you have to try to have something underneath for drainage. So it's very costly and it's very timely to do the split. So this property was split before, and I think that's why we're running into this problem. Before we purchased it, it was unaware to us that this was going to be something to hold us back to be able to build 2 homes. There are other similar properties that are nearby that have similar circumstances like ours and have been allowed a variance. We're hoping that you understand that this is not an income-based unit. We're not going to try to rent it or sell it. We're going to be living there until the end of our days. They're going to help us through our elderly years. My wife and I are getting ready to retire soon in the next year or 2. So we're hoping that the houses can be separated for privacy. There'll be no increase in traffic in that area. It's a dead-end street. I already have 2 letters from 2 of my neighbors to be there. We're going to try to maintain the natural and rural character of the neighborhood. I'm not sure if you're aware, but the county approached us, I would say 3 or 4 months ago, and asked us to donate 5 feet of our northern part of our property so that they can upgrade the road that is super substandard. And so if that comes out to 790 square feet if we're going to give 158 feet of our northern track and 5 feet of property. We're hoping that there could be a return for that, if you know what I mean. We're not asking for any money. We're just looking to the board to help us out here with that. Does anybody else want to add anything?
Okay, thank you. Anyone in the audience opposed? All right, let's open it up for discussion.
Michael, a question. This could be subdivided?
Yes, and a little history on it is the property was split before. The property to the south of it, this was one property. Their portion was split off. So when they came in 2022 to do 2 houses on it, it does require site plan review as a 2-lot subdivision and then would require platting because you can only by Florida law split a property 1 time before having to plat. But the density, the size would allow for 2 single-family detached homes.
Would you say that again? You can only split it under Florida law. You can only split property 1 time.
1 time before having to go through platting.
So was it split?
So it's
prior-
already been split.
It already was
So it was
split.
split once. Was it prior to your?
It was originally a 2.8 acre lot. He split it in half. He built his own home, sold it, and then the other half he sold to us. Unknowingly, we didn't know that there was a rule about that.
Gotcha.
And he didn't either, by the way, because he
Okay.
never told us.
Okay, so to split it now, we would just have to replat this piece? I mean, how difficult is this?
You have to, site plan review, so it comes in as a subdivision site plan. It's 2 lots, whether it's 2 lots, 10 lots, 100 lots, it's all reviewed the same, which they started that process. They submitted a site plan at that time, came in for review. I guess the issues that they had, that they did, is economic, that they didn't want to address, saying the cost to
It's
have it
extremely
done.
expensive to have that.
They were telling us $250,000 just to prep the land before we could even build.
Not the county.
How long is that
Correct, not the
process?
county.
Oh, yeah, no.
We were told that the permitting was going to be about 14 months.
How long is that process?
To go through, so full site plan, depending on how quick, we can get through a site plan in 6 months, then you have plating, could be another 6 months. Plats have to be approved by the Board of County Commissioners.
And we've been at this now, April will be 3 years since we purchased the property. I'm not getting any younger.
Stand in line.
So the way to get around this is to make it an accessory, except it's too large.
Correct, you can have an accessory dwelling
Accessory
unit
buil-
up to 750.
Okay.
I mean,
If
it is
is
1.4
approved as-
acres.
If it's approved as an accessory structure, there's no limitations as to the use. They can have kitchens and bathrooms and, I mean, at one time, accessory structures were intended to not be living quarters. But I
This is
think-
accessory dwelling unit, which would have a separate kitchen unit, so separate living, separate kitchen, facilities in there. And that's you're allowed to have up to 750 square feet, so it's basically, it's a separate dwelling unit. You have all your amenities in there. You're requesting larger ones.
What was the basis of creating a rule that you can only split something once? Just curious.
I have to ask the state,
like
that's a state requirement.
Under Florida statutes, it's required once you divide a parcel a certain number of times, you trigger Chapter 177, and
Let me ask this.
No, I understand. Yeah, but
sir.
what?
just to make sure that you have some uniformity, just like everything else. Otherwise, it arose from the land boom of the 1920s, where everybody had a plat that looked a little bit different, and we had chaos in the state, and we still have chaos in the state from those plats in some cases that are out there, and as this population expands. So it's to bring in some uniformity of regulation. It's tougher on folks who just you want to do a smaller plat like this, but yeah, that's the triggering factor of the vision.
They could build this as an addition to their house, right? If it was attached?
If it was attached, you can't have
A second
another
stove.
second kitchen.
There's that
Second, the
stove.
kitchen becomes a problem.
Yeah.
The issue here is, this is a huge ask. This is more than double the square footage is allowed. That's the problem with me, and I don't know what everybody else's is. Is it possible to do something smaller?
Pick a number.
750?
No, the variance is what we're asking for, so you have to go up a little.
Yeah,
So,
Well, the board can't do that.
is there any?
You've done it in other instances, though.
Sure.
Yeah, is there any precedent for this exchange of space that the county's asking for? So tell me the number again. The county's asking
5 feet, 158
Length.
length, which is on the north side of the property. That's what they're required approximately to be able to fix the road. Because
Right.
it's substandard. Has anybody been down there?
I drove down there.
Yeah, you need a four-wheel.
I bailed, and it's pretty nasty road.
And there's neighbors that go up and down the street all day long. They also go by my property because I'm the last house there, the last property. when they see the horse shed that's still there, and all the stuff that the former owner left,
Yeah.
you know, it's an eyesore for them. My only thing is that if we build, it would upgrade the property.
You said horse shed, right?
horse shed. You can call it a stall if you want.
I
to.
didn't.
That
I
depends
saw
on which
one, but
part
not
of the
the
country
other.
you're from.
Yeah. Okay.
So let me continue with this just a minute. My thought here, and while I know you say you want to live here forever and they're going to live here forever, things happen.
Yeah.
So then we'd be left with someone else owning this at some time and a possible rental unit on the back, which would be totally is not.
You can put that in a
accessory
contract
dwelling,
if you wish. It'll
So
it'll
we
be used as a
have a
rental.
problem with that. So if we'd even consider this at some size, we could put a restriction that this could never, that of record, could never be rented, or Michael, help me out here.
What to do. Yeah, that's hard to think.
I don't think we can restrict, because I think accessory dwelling units are allowed to be
Rented.
rented. You know, the a potential issue could be.
Okay, so that's not an issue. I got it.
Is
then.
if they sell it in the,
Okay.
future, somebody wants to subdivide it,
I
split
got
the
it.
lot, they're going back through that process.
Okay.
That restriction would not effectively run with the land because of what would happen later with a subsequent owner, so.
But it's a reality, so
Well,
I
these
mean,
are the
deal with
subsequent
reality
owners,
too.
right here.
Right.
Well,
They'll get everything.
but we're looking at 30, 40 years down the road.
30,
And-
40 years down the road.
Yeah, fine. But at some point,
Sure.
they may want to sell off one or the other of
Well, then
of
none
these
of us
two
will be
things.
here.
And the point is, you can't. At that point, it's all or nothing, isn't it? Or you'd have to plat it.
Or you'd have to,
So you
It
can't
has to be
just sell
sold
off
as two
part of
lots.
it,
Sell part
you,
of it.
not him,
Yeah.
you.
Yeah, you
Right.
can't
Your
carve
kids
them
are
off.
grown up and out of college.
Yeah.
So what's the
You're
difference?
stuck with the whole place. You have to sell it to you have to have a buyer that will buy the whole
Somebody
thing.
will buy it.
We're gonna be stuck with it whether it's one giant house or two separate houses, ultimately.
It's still the same density whether we're attached or detached.
And the preference is to
The pool
be,
of buyers for that is going to be less than.
Yeah.
So I just I have a question about the horse shed because I saw it and it looks like it's about ready to fall down in various areas. So part of the development on your side would requires to move that.
no, we're
out
going to
of-
destroy that.
You're going to take it
Yeah,
out,
yeah, take it
right?
out. Right.
But if you don't get this, it stays
It stays.
until it
It's an
falls
eyesore. It's an
further.
eyesore, yeah.
Yeah, I got you. And then, so what's the difference here on the 750 to the 878? So like the maximum allowed to build is 750,
yes.
but I see here it says the allowed by code 878.
No, 750, they're increasing, they're exceeding it by 870.
Got it. Okay. All right.
But we're giving you 790 square feet.
We can come down in square footage if it'll help.
Would you still give the?
Oh, yeah, no, that's a done deal because I want to do
They'll
good
take
for
it.
the.
No, they'll take it.
No, that's a done deal because, we want to do good for the neighborhood. Those are going to be my neighbors.
Yeah.
I mean, they're going to be grateful. There's a
that's-
Mr. Burpee who lives
can't get
actually 3 houses down from the property. He's been trying to get that road to be redone for the last 15 years.
And then what about the neighbor with the handicap drive?
And there's a neighbor with a handicapped kid who needs occasionally to take the kid to the hospital, and that road is rough.
Well,
And I'm not asking anything in return for the property. How's that? I'm giving it all
We're,
for free.
we're not selling properties. Or
I don't think what the applicant is asking for is an intrusion upon the intended use of the properties, and it's a technicality that
Right, it is
it
a
can't be
technicality.
divided. That if it could be divided, you could fit 2 houses on this property comfortably, and it would work. The inconvenience that would occur as a result of an approval of this action is that these would forever be twins on a lot and have to be sold as twins, could not be separated in the future, although it's not out of the question that a plat could be created in the future and it could be sold.
It just would cost 5 times as much.
Yeah, but, I mean, it's not impossible. It's a hardship now to have to go through the platting of this, the time and expense involved. which won't result in any different outcome than would be if it were approved as an accessory dwelling. You would have the same end result. You'd have two lots on the same size property, or two houses on the same size property. So I personally think that the hardship here is that the unusual circumstance and hardship and the practical difficulty is that the property had previously been divided, and it precludes it from being divided again. Not because of the size of it. The size is ample to accommodate it. So I'm going to make a motion to approve this.
Can I ask one question real fast? Could it have been divided that first time into 4 pieces, or did it have to be divided?
It would have been platted. So you can divide it one into two for free by the state.
okay.
Anything more, you're going through the platting. Yep.
Okay, all right.
That's correct.
I forgot what I was saying now.
You were making a motion, I'm sorry.
Get a motion
You're
to,
interrupting me,
yeah.
yeah.
I'm sorry.
I would like to move to approve. The findings of fact being that there's a hardship created by the pre-existing condition of the property having formerly been divided, and the practical difficulty of trying to replat it at this time for the two houses. And based on those findings of fact, I'm going to move for approval.
And I'll second that because I interrupted you.
And then that, we would add getting out the proper permits and going through.
Sure.
Whatever you need.
Yeah, so, okay, we have a motion and a second. All in favor?
Aye.
Aye. Any opposed? All right, congratulations. The county thanks you for the land, and
Totally.
and your neighbors thank you for the new road that will eventually come about.
Thank you.
All right, you're welcome.
Next.
All right.
Good job.
So our next
That's a field
case has unusual development that I'd like for
Yes, and I
you
don't,
to walk through.
I don't have the communication itself, but it's my understanding that spoke to, maybe Brendan McAsee of our office can come up and speak to it. But the Neighbors Council has a difficulty that we were contacted about this morning.
Thank you, Daryl. Michael, Kevin, members of the board, always a pleasure to be before you. At 1:54 a.m., counsel for the applicant, Craig Taraski, and I received an email from counsel for one of the objecting neighbors, the Janesh's. Basically, counsel has a personal emergency. She requested that this matter be continued, recognizing that staff certainly can't speak for the applicant and that the continuance, of course, lies within the discretion of this board. Staff does not object to any continuance, whether it be to March or April. It just requested it be, if that's the board's wish, set out to a date certain.
Daryl, I believe you want to comment on this too.
Well, and I think we should see if what the applicant's status is first before I say too much.
Craig Taraski for the applicant. Yeah, unfortunate development, but my client is ready to go today. They actually had to travel in for this. There's logistics involved. They've been waiting a long time to come before you. I'm not going to speak for the objectors, but my expectation is that their objection is probably not based in any hyper-technical legal type of argument. It's probably more based on the quiet enjoyment of their property and not wanting to be intruded upon. And if the objectors are here today, I think they're probably well-versed to express that to you today so that we can move forward.
All right, so.
And I think it would be good to have on the record, if the objective parties are here today, even though their counsel is not, for them to come forward and formally ask for the continuance, because we don't have that on the record.
Anyone in the audience in objection of this request, come up and state your name and address and let us know what you're thinking.
Good morning. I'm Justin West, one of the property owners in Ryan's Woods HOA. I'm also on the board for Ryan's Woods HOA. And in this situation, I'm the closest house other than the Janishes. I actually have the only single-family home that's on the HOA property. The Janishes are to the north of me. At first, initially, I was not opposed to it.
Sir, so we're not going to the substance of the application right now. What we're going to is it your counsel that is unable to attend? Whose counsel is
No,
unable to attend?
you wanted to know if I objected, correct?
Object to the continuance.
Oh, I'm sorry. Oh, I thought
Yeah,
you said objected.
what I'm looking for
No,
is
I don't
the-
object to the
the,
continuance,
whoever's
but I.
attorney
Actually
is
asked for the
Phil.
continuance.
we need you to
I
ask.
didn't hear that part, sorry.
Yeah.
All right, so I do believe there's a woman behind you who has stood and seems to be expressing that sentiment.
So,
It's my counsel that is having emergency surgery this morning, so I would like to ask for the continuance as I'm not versed in the
Could you put your name
legalese.
and address in the record, ma'am?
Oh, sorry, Christine Janish, 672 Soundview Drive.
And where do you live in relation to the site that's seeking the variance?
I'm the neighbor to the north.
You're a adjacent neighbor?
I'm the Janishes, yes.
Okay.
and you don't feel like you'd be represented without your counsel here?
I think she's prepared the documents. I mean, I think she was going to explain it all.
You have the option of presenting the case without counsel if you want today.
I'm not a lawyer.
It doesn't
That's
matter, we're
fine.
not judges either. But yeah, I mean, it is your option. We're happy to entertain the motion for continuance, which would.
Well, I'm
we
asking
usually-
for it, and then you can decide.
Okay.
Okay, so we've been asked for a continuance. Any comments?
No, I think it's a courtesy that we have established before. It's an inconvenience, I know, to those who came here today and those who may have traveled to come here today, and I apologize for that, but it's a courtesy that we commonly have extended when unforeseen circumstances arise. So I would move to continue the case until a future date established by staff.
We have March 6th is the date for a March hearing, or April 3rd for the April.
I believe we only have one case for March. It would be nice to have, it'd be good timing.
Assuming their counsel is able to.
Or get a new counsel at this point. I think you have that option too, so.
Is there a limit on continuances or?
No.
Okay.
If it's a date certain, we don't, there's no need to renotice, re-advertise.
We could, at the next meeting, if we want to continue it again, we have done that.
Can we get some input from the applicant about whether it's March or April?
Yeah, that's what I wondered.
No.
The applicant.
Well, that's why I was asking staff to schedule it rather than us
Yep,
making
I get
a
that.
date certain.
But the applicant's
Okay.
here.
What if the applicant would
It's here,
prefer
though.
April?
My understanding was the applicant had to fly in for
Yeah,
this
yeah.
hearing, so if they're gonna
Yeah.
have to fly in for the next hearing,
Yeah.
would be better in March or April. We're asking them.
Hi, my name is Stephen Kuchar, 600 Pennsylvania Avenue, Palm Harbor, Florida. I traveled here from Virginia for this. I'm a physician. I don't know my schedule. I'd have to look at it, but I can't tell you right now whether I can get off in a month or not. I've had this book for 4 months. So, traveled down here by car. I understand difficult circumstances, but it's difficult for me too.
If your counsel was here, would you be available through like? His
counsel is here.
His
I'm
counsel is
sorry,
here.
I'm sorry. Would you be available through electronic means?
Possibly, yes, sure, yeah. If I have to. yes.
We have done that.
Okay, so is it safe to assume you'd rather get it sooner than later?
Yes, I've been waiting 3 years. I'd love to.
Okay, so we have a request for continuance on the table.
And just let me add, since we had at the earlier meetings discontinued the virtual thing, I think we could make an exception.
You would have
for
to
this
move.
case.
I was going to bring that up because we actually
Yeah.
discontinued remote appearances, so there would need to be a motion and vote to
And I would make that-
reinstate that
if you
policy
make me
at the
make that
beginning
part
of
of the
that
motion,
meeting for
that
the
would be-
cases for that
You
date.
can do that as a one-off, right?
Yes.
Well, I would do it for that meeting
I mean,
in its
yeah, that-
entirety, so that we're not, so that everybody of that date would have that same option.
All right, so the request is continuance plus allowing online presence. If necessary due to.
All cases that day should have
travel and
online
schedules.
access.
For you.
All right, so that request.
Yeah.
Yep.
I was going to ask the objector, do you know whether your counsel would be able to appear in a month, or is this something?
This was just an emergency. I think a month would be fine.
Okay.
Okay.
All right.
March 6th.
Move to continue to March 6th.
With
the ability to appear online.
I think we have to do that the day of the hearing.
We could, It's okay to include it now. We'll
Is it?
we'll probably just restate it that date and make sure it's
we-
clear on the record.
All right, so the motion is for both continuance and online presence in the event of travel challenges.
Can we also add that if the, if he side chooses so, we will not continue it again?
No, I wouldn't do
No.
that. You don't, you know.
Okay, all right.
I would take each continuance up as it comes,
yeah.
and then you can, each continuance request up as it comes. So if this happens again, you get another vote.
So, okay, so we've got a request for continuance and online presence if need be based on travel restrictions or the ability to travel.
That's my motion.
And we've got a motion
Second.
and a second. All right, all in favor?
Aye.
Opposed? All right. Okay, let's see here. So I need a motion to approve the minutes for our last meeting.
Move to approve the minutes for last meeting.
I have a
There's
motion.
four.
In the meeting before,
Oh, two, okay,
meetings
for
worth.
both, previous months. The motion is for,
for both meetings.
yep, we have a motion. I need a
Second.
second. All right, we have motion and second. All in favor?
Aye.
Aye. All opposed? Great.
I got one other thing.
One more thing.
This is Karen's last meeting.
Who?
Karen, our staff. So this will be her last meeting with us, so.
Retiring or?
Will we be able to get in?
Yeah, well, we all get the door.
Yeah, she's gonna leave her card, the access
Okay.
card, so we can get in.
Is it hanging from
Well,
a
Karen,
string?
I hope you're moving on to greener pastures. It's hard to believe that there are greener pastures than we currently occupy, but congratulations. All right.
Thanks,
so,
Karen.
Anything else?
That's it.
All right.
Thank
That's
you.
it, folks. Thanks.
Close.